Hello, my name is Donna Newman and I am a partner in the Finance Litigation Group at Stevenson Harwood. Welcome to the second in our autumn 2018 series of 4 short webcasts in which we take a bite-sized look at some key topics that have emerged from court or regulatory decisions over the last year. In today's webcast, Ben Sigler, a partner in our Finance Litigation Group, will be discussing the practical implications of the Court of Appeal's judgment in SFO versus ENRC, one of the most important judgments of the last 12 months. The ENRC decision provided clarification regarding the circumstances in which legal professional privilege will attach to documents created in the context of internal investigations.
Welcome to our webinar on the Court of Appeal's judgment in the SFO and ENRC. This judgment overturned an earlier controversial judgment of Mrs. Justice Andrews, pursuant to which ENRC was ordered to disclose documents created by external solicitors and forensic accountants in the course of an internal investigation into alleged corruption to the SFO, as they were not covered by litigation privilege, as ENRC had alleged. In overturning Andrews J's judgment, the Court of Appeal has restored the previously understood orthodoxy around the scope of litigation privilege, giving companies and their advisors reassurance that documents created in the course of internal investigations into alleged criminality may be capable of being privileged against disclosure. In December 2010, ENRC received an email from an apparent whistleblower alleging corruption and financial wrongdoing at ENRC's Kazakh subsidiary, and instructed solicitors in London to investigate the allegations contained in the email. Thereafter, allegations of corruption involving ENRC reached the public domain. In April 2011, an MP wrote to the SFO asking it to investigate ENRC's business in Africa, and in August 2011, The Times reported on the allegations relating to ENRC's Kazakh subsidiary. Emails from spring 2011 demonstrated that, at that time, ENRC's General Counsel and Head of Compliance were concerned about the prospect of an imminent dawn raid by the SFO. By summer 2011, ENRC's investigation, conducted by its London solicitors, had expanded to cover allegations of corruption in both Kazakhstan and Africa. Forensic accountants had been instructed to conduct a books and records review, and ENRC solicitors also began conducting interviews with ENRC's current and former employees. On the 10th of August 2011, the SFO wrote to ENRC regarding recent intelligence reports and media reports concerning allegations of corruption and wrongdoing by ENRC. The SFO's letter invited ENRC to a meeting to discuss the allegations and urged ENRC to consider its July 2009 self-reporting guidelines. However, the letter concluded by saying that the SFO was, at that stage, not conducting a criminal investigation into ENRC. Throughout the remainder of 2011 and the entirety of 2012, ENRC's investigation continued. ENRC's solicitors were in regular dialogue with the SFO about its progress, indicating a willingness to share the fruits of their investigation with the SFO, and met with the SFO to provide periodic updates and also provided updates on the investigation to the board of ENRC. In March 2013, no formal report from ENRC having been provided in relation to the outcome of its investigation, the SFO served a compulsory notice on ENRC solicitors under Section 2 of the Criminal Justice Act 1987, seeking disclosure of documents relevant to its determination of whether a criminal investigation should be opened. ENRC asserted legal professional privilege over the documents, disclosure of which had been sought. In February 2016, the SFO issued a part 8 claim against ENRC for a declaration that legal professional privilege did not, in fact, attach to 4 specific categories of documents, disclosure of which had been sought from ENRC's solicitors. Category 1 were notes taken by ENRC's solicitors of interviews with current and former employees of ENRC, which were created between August 2011 and March 2013. Category 2 was material generated by the forensic accountants that were instructed to undertake the books and records review. These documents were created between May 2011 and January 2013. Category 3 were PowerPoint slides used by ENRC solicitors to provide briefings on the investigation and legal advice to the Board and Corporate Governance Committee of ENRC. Category 4 were 9 reports generated by the forensic accountants and 6 emails and letters enclosing copies of those reports. It also included 2 emails dating from October 2010, which were sent to and from ENRC's Head of Mergers and Acquisitions, which ENRC asserted were drafted for the purposes of seeking legal advice on its behalf. At first instance, Andrews J granted the declaration sought by the SFO in respect of categories 1, 2 and 4, holding that legal professional privilege, either legal advice privilege or litigation privilege, did not attach to the documents. Litigation privilege applies to communications between a client or its lawyer and a third party made in connection with adversarial litigation, provided that litigation is in progress or in reasonable prospect and the communications of the sole or dominant purpose of conducting that litigation. Andrews J held that litigation privilege did not attach to the documents as adversarial litigation was not reasonably in contemplation before the documents were created. In August 2011 or before, ENRC may have reasonably contemplated a criminal investigation. However, for the purposes of litigation privilege, reasonable contemplation of a criminal investigation, which Andrews J considered did not amount to adversarial litigation, is not the same as reasonable contemplation of criminal prosecution. Andrews J emphasised that in her view, there was a critical difference between civil and criminal proceedings, in that there's no inhibition of commencement of civil proceedings where there's no foundation for them. By contrast, criminal proceedings cannot be commenced unless a prosecutor is satisfied that there is sufficient evidential basis for prosecution and that the public interest test is met. In any event, even if litigation had been in reasonable contemplation, Andrews J held that the documents were not created for the dominant purpose of conducting that litigation. The solicitors who generated the Category 1 documents were instructed as information gatherers rather than as legal advisors. Taking legal advice in relation to the conduct of future contemplated criminal litigation was not even a subsidiary purpose of the creation of those documents, let alone the dominant purpose, and the dominant purpose of the Books and Records Review was plainly to meet compliance requirements or to obtain accountancy advice on remedial steps. Finally, she also held that in November 2011, ENRC's General Counsel wrote to the SFO indicating that the product of the internal investigation would be shared with the SFO and, in Andrews J's view, documents created with the specific purpose or intention of showing them to the potential adversary in litigation were not capable of being subject to litigation privilege. Legal advice privilege applies to confidential communications passing between lawyer and client in connection with the giving or receiving of legal advice and covers both documents containing or requesting legal advice and documents which form part of the continuum of communications between lawyer and client as part of the process of giving and receiving legal advice. Andrews J rejected ENRC's claim to legal advice privilege in respect of the interview notes and the October 2011 emails, holding, amongst other things, that following Three Rivers, number 5, employees who were interviewed by ENRC solicitors were not authorised to seek and receive legal advice on behalf of ENRC and were not, therefore, part of the client team, and accordingly, communications with them, including those recorded by the interview notes, were not subject to legal advice privilege. Legal advice privilege was held by Andrews J to attach to the PowerPoint slides. She held this because the evidence showed that they were prepared for the purposes of giving legal advice to the board, as opposed to merely reporting factual findings, and were thus plainly privileged, even though the PowerPoint slides made reference to factual information that would not otherwise be privileged. In addition, legal advice privilege attached to any record of what the solicitors said at the board meetings, even if reference was made to information therein which would not otherwise be privileged. The Court of Appeal rejected Andrews J's findings on litigation privilege, finding that litigation privilege attached to the documents in categories 1, 2 and 4, except the October 2011 emails. The Court of Appeal held that this was a question of fact, and whilst it is not clear that every SFO manifestation of concern would properly be regarded as adversarial litigation, in this case, litigation was in reasonable contemplation when the SFO commenced its investigation in April 2011, and certainly by the time it received the SFO's August 2011 letter, emphasising that the entire subtext of the relationship between ENRC and the SFO was the possibility, if not the likelihood, of prosecution. In making this finding, the Court of Appeal appeared to place weight on, amongst other things, evidence that ENRC had received advice from its solicitors in April 2011 to the effect that both criminal and civil proceedings can be reasonably said to be in contemplation. Notably, the Court of Appeal also recognised that an international corporation, as opposed to an individual, will often be uncertain as to the nature and extent of any potential criminal liability, and will need to conduct an investigation before it can say with certainty that proceedings are likely. But this uncertainty would not prevent proceedings being in reasonable contemplation. The Court of Appeal also rejected Andrews J's distinction between litigation privilege in civil and criminal contexts as illusory, finding that it would be wrong for it to be thought that, in a criminal context, a potential defendant is likely to be denied the benefit of litigation privilege when he asks his solicitor to investigate the circumstances of any alleged offence. The Court of Appeal held, contrary to Andrews J's analysis, that documents created to avoid, as well as to resist proceedings, were protected by litigation privilege, and that this was the dominant purpose behind the creations of the documents in categories 1, 2 and 4, with the exception of the October 2011 emails. Although ENRC had initially instructed its solicitors to investigate the whistleblower's allegations and subsequently the Africa allegations, the Court of Appeal concluded that the investigation must be brought into the zone where the dominant purpose may be to prevent or deal with litigation. Following high-grade traders, the Court of Appeal held that the need to investigate the existence of corruption in this case was just a subset of the defence of the contemplated legal proceedings. Andrews J's finding that the forensic accountant's work product and reports in categories 2 and 4 were created for compliance or remediation purposes and not for the dominant purpose of litigation was rejected by the Court of Appeal, which observed that although a reputable company will wish to ensure high ethical standards in the conduct of its business for its own sake, it's undeniable that the stick used to enforce appropriate standards is the criminal law and in some measure the civil law also, adding that the compliance and remediation work might itself have been intended to avoid or deal with litigation. Finally, Andrews J's finding that ENRC brought documents into existence for the specific purpose of their being shown to the SFO was also rejected. The Court of Appeal held that the fact that a document is created with the specific purpose of being shown to the other side in litigation, for example a response to a claim, does not mean that the advice received in respect of the creation of that document is not privileged. It was held that the discussions surrounding the drafting of such a letter would be as much covered by litigation privilege as any other work done in preparing to defend the claim. The Court of Appeal agreed with Andrews J's interpretation of 3 Rivers No. 5 as limiting legal advice privilege only to those communications between a lawyer and those persons authorised to seek and receive legal advice on behalf of the client. Given its findings regarding litigation privilege, it was not necessary for the Court of Appeal to determine whether legal advice privilege attached to the documents, and therefore whether 3 Rivers No. 5 was properly decided, which it considered should be deferred to the Supreme Court in any event. However, the Court of Appeal did indicate that it supported the submissions of counsel for ENRC and the Law Society, which had intervened in the appeal, that 3 Rivers No. 5 had been wrongly decided, noting that this decision resulted in larger organisations being in a less advantageous position than individuals and small businesses. It held, if legal advice privilege is confined to communications passing between the lawyer and the client, in the sense of the instructing individual or those employees of a company authorised to seek and receive legal advice on its behalf, this presents no problem for individuals and many small businesses, since the information about the case will normally be obtained by the lawyer from the individual or board members of the small corporation. However, we have to cater for legal advice sought by large national corporations and indeed multinational ones. In such cases, the information upon which legal advice is sought is unlikely to be in the hands of the main board or those it appoints to seek and receive legal advice. If a multinational corporation cannot ask its lawyers to obtain the information it needs to advise that corporation from the corporation's employees with relevant first-hand knowledge under the protection of legal advice privilege, that corporation will be in a less advantageous position than a smaller entity seeking such advice. Court of Appeal's judgment will be well received by in-house counsel and external legal advisors alike, where dealing with internal investigations into criminal and regulatory issues. The judgment affords significantly more comfort than Andrews J's controversial ruling regarding the potential availability of litigation privilege in the context of internal investigations. It recognises, entirely sensibly, that the public interest is best served in permitting companies to investigate allegations of wrongdoing with the protection of legal professional privilege, and that if such protections are not available, companies might be tempted not to investigate such allegations at all. This would be entirely contrary to the SFO's policy of encouraging companies to self-report, which is supported by the availability of deferred prosecution agreements. Perhaps most critically, the judgment clarifies that the fact that a company has not yet comprehensively established the veracity of allegations of wrongdoing will not prevent it from asserting that litigation is in reasonable contemplation. However, it must be borne in mind that the facts of this case are exceptional. At the time the whistleblower's allegations came to light, ENRC was a FTSE 100 company. Allegations of corruption were widely aired in the press and were the subject of a letter from an MP to the SFO. For a year and a half, ENRC was in dialogue with the SFO about self-reporting. On these singular facts, it's perhaps unsurprising that ENRC had reason to contemplate legal proceedings from a relatively early stage in its investigation. Most cases where an allegation of criminality emerges bear little or no resemblance to these facts. Therefore, despite the comfort which the Court of Appeal's judgment offers, the question of when criminal litigation is in reasonable contemplation so as to trigger the protection of litigation privilege will, in the vast majority of cases, continue to require careful thought. Indeed, the prudent course may often be for companies to proceed on the basis that litigation privilege will not apply to documents created in the course of an investigation, although it may well be arguable to the contrary, particularly where, for example, the relevant authorities are unaware of the allegations being investigated. That the Court of Appeal considered itself unable to depart from Three Rivers No. 5 is unsurprising, but the Court of Appeal's indication that it would have made a contrary finding on the ambit of legal advice privilege had it been able to do so is noteworthy. So long as Three Rivers No. 5, as understood and applied by the Court of Appeal and ENRC, remains authoritative, companies must take great care in identifying the group of individuals who will act as the client for the purposes of giving and receiving legal advice at the outset of any investigation. Only communications between the client group and legal advisors will be protected by legal advice privilege, albeit they may instead be protected by litigation privilege, to be the case in respect of the interview notes. Factual summaries of any investigation can be protected by legal advice privilege, as the PowerPoint slides were found to be in ENRC. However, this will only be where they form part of the continuum of legal advice which is being provided. It's understood that the SFO intends to seek leave to appeal the Court of Appeal's judgment. However, as yet, no leave to appeal has been granted. If the SFO for permission to appeal to the Supreme Court is granted, it's possible that the question of the proper ambit of legal advice privilege in a corporate context will be determined conclusively in the near future. Finally, the Court of Appeal's judgment reinforces that carefully documenting both the composition of the client team and the basis on which a party considers litigation to be in reasonable contemplation at the outset of an investigation will be critical in substantiating any claim to privilege. The Court of Appeal's judgment also reinforces the view articulated by Vos J and Bilter that early instruction of external counsel may support a claim to litigation privilege, albeit that it will not be determinative of the availability of such privilege. Whilst practitioners were still celebrating the restoration of the status quo by the Court of Appeal in ENRC, Arnold J's judgment in FRC v Sports Direct International, published only a matter of days later, ensured that the status quo regarding legal professional privilege was short-lived. In short, Sports Direct was ordered to disclose to the FRC documents which it, as Sports Direct, had successfully demonstrated were covered by legal professional privilege, on the basis that such documents would be disclosed solely for the purposes of the FRC conducting an investigation into Sports Direct's auditor. Surprisingly, Arnold J considered that such an order did not represent an infringement of Sports Direct's privilege in these documents. However, its practical implications are concerning as, amongst other things, it raises the possibility of the privileged documents obtained by the FRC potentially being relied on in the course of proceedings against Sports Direct's auditor and thereby potentially becoming public, and also that those documents will be shared with other regulators via relevant gateways. Furthermore, this decision may be considered to set a precedent which other regulators may seek to follow. This judgment, which, like Andrews J's judgment in ENRC, is considered highly controversial, is also subject to appeal, and we can therefore expect further significant developments in the law of privilege in the near future.